Okay, so I've been firing out videos like crazy today. It just kind of happens that today is a high study day, so I've got a lot more going on. So let's go ahead and do something really simple. I'm probably just going to read from the books because that's pretty self-explanatory from there. Let's just go ahead and cover the difference between the ADEA and the OWBPA. So these both are laws that pertain to age and discrimination. Both of these apply to organizations with 20 or more employees. I like to make an emphasis on how many employees this pertains to because I believe that this is something that could be on the quiz or test, sorry. So again, both of these are age discrimination. Title VII still protects you from being discriminated on age anyway. These just have a little bit more to it. So let's go ahead and jump right into the ADEA. I'm going to say what they mean in a second. And the OWBPA. So the ADEA of 1967 basically just prohibits the discrimination of employees on the age of 40 years old or older. So just think 40 with the ADEA. So again, Age Discrimination and Employment Act of 1967 pertains to 20 employees or more. So just a little brief history. I'm just going to go ahead and read it because it's short. When this law was first passed, it specified the protected age ranges of 40 to 70. Anyone younger than 40 or older than 70 was not covered for age discrimination in the workplace. Amendments were made a few years later that removed the upper limit. Today, the law bans employment discrimination based on age if the employee is 40 years or older. Remedies under this law are the same as under the Civil Rights Act, Title VII, just going to catch you there, of 1964, okay? They include reinstatement, back pay, front pay, and payment for benefits in arrears. Some exceptions to the unlimited upper age do exist. This, again, is something that will be tested on, so I want to go ahead and make sure that you note this, but the one example of that upper age, unlimited upper age that exists is the rule that airline pilots may not fly commercial airlines after the age of 65. And that has to go with more on health concerns and not being able to perform essential job duties. So then we're going to go ahead and jump into the Older Workers Benefit Protection Act, or OWBPA, of 1990. It's pretty similar to the ADA, but not really. They both have to do with age. So I'm just going to jump into this one too because it's short. And I like the history on this, which I think will help with retaining. So the Older Workers Benefit Protection Act, OWBPA, of 1980, which pertains to companies with 20 or more employees, is now this, what we're going to go into. In the 1980s, it was common for employers, particularly large employers, to implement staff reduction programs as a means of addressing expenses. Often those programs were targeted at more senior workers because, generally speaking, their compensation was greater of that than the new employees. Reducing one senior worker could save more money than the reduction of a few recently hired workers. Congress took action to prevent such treatment based on age when it passed this law. The key purpose of the Older Workers Benefit Protection Acts are to prohibit an employer from the following three things. 1. Using an employee's age as the basis for discrimination in benefits. 2. Targeting older workers during staff reductions or downsizing. Or 3. Requiring older workers to waive their rights without opportunity for review with their legal advisor. So when it comes to age, other than Title VII, and you cannot be discriminated based on your age, understand that the ADEA has a lot to do with pay discrimination on being 40 years or older, with the exception of airline pilots at 65, and with the OWBPA, or the Older Workers Benefit Protection Act of 1990, that really just has to do with discriminating on older employees when it comes to downsizing and layoffs. So yeah, that should cover you. If you can remember those few things, you should be good to go for your exam. Thank you for watching.